So, very good evening, all the participants. Today we'll see this part 5 of IBC, miscellaneous. Section 224. Section 224 says there shall be formed a fund to be called the Insolvency and Bankruptcy Fund. Herein, after in this section referred to as the fund for the purpose of insolvency resolution, liquidation, and bankruptcy of persons under the code. So there is a fund called Insolvency and Bankruptcy Fund. Now this fund is different from the fund which we saw in case of liquidation, because when the liquidation is complete, but there are certain funds, then those funds are also transferred to a particular account. What is that account? Can anybody tell me? What is that account?
Consolidated fund of
Yeah.
consolidated.
Consolidated Fund of India is the actually that is ultimately transferred to that account. But prior to that, when the payments have been made and there are, before he files an application for dissolution, the liquidator transfers the funds which are lying unutilized to a particular fund. What is the fund, name of that fund?
Insolvency bankruptcy fund.
Any other reply? That is actually corporate liquidation account.
Corporate liquidation. Yes.
That is the corporate liquidation account. And in case of voluntary liquidation also, there is a similar account that is called voluntary corporate voluntary liquidation account. So, but this account is different. The point here was that this account is different from the insolvency and bankruptcy fund. So, in case of liquidation also, when there are certain funds which are unclaimed, so they are transferred to the corporate liquidation account. But this account is different. This is not the same as insolvency and bankruptcy fund. So there shall be formed a fund to be called the Insolvency and Bankruptcy Fund, hereinafter in this section referred to as the fund for the purpose of insolvency resolution, liquidation, and bankruptcy of persons under the code. There shall be credited to the fund the following amounts, namely the grants made by the central government for the purposes of the fund, the amount deposited by persons as contribution to the fund, the amount received in the fund from any other source, and the interest or other income received out of the investment from the fund. So these are the credits. And suppose a person who has contributed any amount to the fund may, in the event of proceedings initiated in respect of such person under this code before an adjudicating authority, make an application to such adjudicating authority for withdrawal of funds not exceeding the amount contributed by it, for making payments to workmen, protecting the assets of such persons, meeting the incidental costs during the proceedings, or such other purposes as may be prescribed. Suppose a person contributed a certain sum, say 2 crores. Now that person is into CIRP. So he can make an application to the adjudicating authority for withdrawal of funds not exceeding the amount contributed by it. And that is also for particular purposes, for making payments to workmen, protecting the assets of such persons, meeting the incidental cost during the proceedings, or such other purposes as may be prescribed. And the central government shall by notification appoint an administrator to administer the fund in such manner as may be prescribed. So this is regarding insolvency and bankruptcy fund. Now section 225. What it says, power of central government to issue directions. Without prejudice to the foregoing provisions of this code, the board shall, in exercise of its powers, or the performance of its functions under this code be bound by such directions on questions of policy as the central government may give in writing to it from time to time. So central government has the power to issue directions. So board shall be bound by such directions on questions of policy as the central government may give in writing to it from time to time, provided that the board shall, as far as practicable, be given an opportunity to express its views before any direction is given under this subsection, and the decision of the central government as to whether a question is one of policy or not shall be final. So this section basically talks of supremacy of the central government over the board. Now, section 226. Section 226 says power of central government to supersede board. So this is not 224, this is 226. So power of central government to supersede board. If at any time the central government is of the opinion that on account of grave emergency, the board is unable to discharge the functions and duties imposed on it by or under the provisions of this code, or that the board has persistently not complied with any direction issued by the central government under this code, or in the discharge of the functions and duties imposed on it by or under the provisions of the code, and as a result of such non-compliance, the financial position of the board or the administration of the board has deteriorated, or that the circumstances exist which render it necessary in the public interest so to do, the central government may by notification supersede the board for such period not exceeding 6 months. So the central government may by so they have to issue a notification. So they can supersede the board for such period not exceeding 6 months as may be specified in the notification. Suppose the board is not functioning properly, or there is non-compliance, continuous non-compliance, or there is a public interest. So in such cases, the government may issue notification and it may supersede the board. Upon the publication of a notification under subsection 1, superseding the board, all the members shall, as from the date of supersession, vacate their offices as such. All the powers, functions, and duties which may, by or under the provisions of this code, be exercised or discharged by or on behalf of the board shall, until the board is reconstituted under subsection 3, be exercised and discharged by such person or persons as the central government may direct. And all property owned or controlled by the board shall, until the board is reconstituted under subsection 3, vest in the central government. So in this case, the central government may, by way of a notification, supersede the board for a period not exceeding 6 months, and the powers of the members of the board shall cease, and they will be exercised and discharged by such person or persons as the central government may direct. On the expiration of the period of supersession specified in the notification, which cannot exceed 6 months, the central government may reconstitute the board by a fresh appointment, and in such case, any person or persons who vacated their offices under clause A of subsection 2 shall not be deemed disqualified for appointment. So it means they may be reappointed also, provided that the central government may at any time before the expiration of the period of supersession take action under this subsection. The central government shall cause a notification issued under subsection 1 and a full report of any action taken under this section and the circumstances leading to such section to be laid before each House of Parliament at the earliest. Now section 227, power of central government to notify financial sector providers. This is very important section, because normally a banker can take a company into IBC, but a company cannot take bank into IBC except through this section. So it is within the, because part 2 we saw it is not applicable to financial service providers. Because in part 2, when we saw the definitions, we read that this part, it will not apply to financial service providers. So can you tell me the exact section or subsection where it is written that this does not apply to financial service providers?
Sir, section 3, point number 7.
Section 3,
Point number 7, sir.
point number 7.
Corporate person.
Corporate person, yes. So it says it shall not include any financial service provider. Now, so where financial service provider is covered? It is covered in section 227. So, notwithstanding anything to the contrary contained in this code or any other law for the timing in force, the central government may, if it considers necessary, in consultation with the appropriate financial sector regulators, notify financial service providers or categories of financial service providers for the purpose of their insolvency and liquidation proceedings, which may be conducted under this code in such manner as may be prescribed. Like there was a case of Diwan Housing Finance and so many other companies. So in such a situation, what the central government does is central government consults the say RBI, which is the regulator for these NBFCs, and then they issue a notification that okay, such and such companies will be coming under this IBC, and the uh, person who is controlling all this is called the administrator, which may be conducted under this code in such manner as may be prescribed. For the removal of doubts, it is hereby clarified that the insolvency and liquidation proceedings for financial service providers or categories of financial service providers may be conducted with such modifications and in such manner as may be prescribed. So there are rules 1 to 10 for this. Now, section 228. Section 228 talks of budget. So, the board shall prepare in such form and at such time in each financial year as may prescribe its budget for the next financial year, showing the estimated receipts and expenditure of the board and forward the same to the central government. So, board is preparing a budget for the next financial year. Then annual report. The board shall prepare in such form and at such time in each financial year as may prescribe its annual report, giving a full account of its activities during the previous financial year and submit a copy thereof to the central government. And a copy of the report received under subsection 1 shall be laid as soon as may be after it is received before each house of parliament. Now section 230. Section 230 talks of delegation. The board may by general or special order in writing delegate to any member or officer of the board subject to such conditions if any as may be specified in the order such of its powers and functions under this code except the powers under section 240 as it may deem necessary. So basically the board may by general or special order in writing delegate to any member or officer of the board except the powers under section 240. Now what 240 says? 240 I think talks of make power to make regulations. Now 231. 231 talks of bar of jurisdiction. So no civil court shall have jurisdiction in respect of any matter in which the adjudicating authority or the board is empowered by or under this code to pass any order, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any order passed by such adjudicating authority or the board under this code. So normally the courts are kept at bay because in earlier regime what happened was whenever there was an order, a stay was granted. But here there is no jurisdiction of any civil court. So if an order is passed by the adjudicating authority, nobody can grant any injunction or stay. So that is why the things are expedited under IBC. So no civil court shall have jurisdiction. Now 232 members, officers and employees of the board to be public servant. So the chairperson, members, officers and other employees of the board shall be deemed when acting or purporting to act in pursuance of any of the provisions to be public servants. Now the question arises here whether a RP or IRP is a public servant. The answer is no. Who are public servant? Members, officers and employees of the board. And IRP or RP is not covered. Then protection of action taken in good faith. No suit, prosecution or other legal proceeding shall lie against the government or any officer of the government or the chairperson, member, officer or other employee of the board or an insolvency professional. So insolvency professional is covered here, or liquidator, for anything which is done or intended to be done in good faith under this code or the rules or regulations made thereunder. So if anything is done under good faith, then no suit, prosecution or other legal proceeding shall lie. Then agreement with foreign countries. Section 234. The central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this code, because sometimes the assets or liabilities of a company are in different jurisdictions, in different countries. So the central government may enter into an agreement with the government of any country outside India for enforcing the provisions of this code. The central government may by notification in the official gazette direct that the application of the provisions of this code in relation to assets or property of the corporate debtor or debtor, including a personal guarantor of a corporate debtor, as the case may be, situated at any place in a country outside India with which reciprocal arrangements have been made, shall be subject to such conditions as may be specified. Now section 235. Section 235 talks of letter of request to a country outside India in certain cases. So notwithstanding anything contained in this code or any law for the timing in force, if in the course of insolvency resolution process or liquidation or bankruptcy, the resolution professional, liquidator or bankruptcy trustee as the case may be, is of the opinion that the assets of the corporate debtor or debtor, including a personal guarantor of the corporate debtor, are situated in a country outside India with which reciprocal arrangements have been made under section 234, he may make an application to the adjudicating authority that evidence or action relating to such assets is required in connection with such process or proceeding. And the adjudicating authority, on receipt of an application under subsection 1 and on being satisfied that evidence or action relating to assets under subsection 1 is required in connection with insolvency resolution process or liquidation or bankruptcy proceeding, may issue a letter of request to a court or an authority of such country competent to deal with such request. Okay. Now 235A, punishment where no specific penalty or punishment is provided. So if any person contravenes any of the provisions of the code or rules or regulations for which no penalty or punishment is provided, such person shall be punishable with fine, which shall not be less than 1 lakh rupees, but which may extend to 2 crore rupees. So 1 lakh to 2 crore. Otherwise, specific penalties are there, but if any action is not covered under any of the provisions, then 1 lakh to 2. Then 236, trial of offences by special court. So notwithstanding anything in the code of criminal procedure, offences under this code shall be tried by the special court established under chapter 28 of the Companies Act. Now suppose there is a provision for imprisonment, so then trial of offences by special courts will be there. No court shall take cognizance of any offence punishable under this act, save on a complaint made by the board or the central government or any person authorized by the central government in this behalf. So, who will make complaint? Complaint will be done by the board or the central government or any person authorized by the central government in this behalf. And the provisions of the Code of Criminal Procedure shall apply to proceedings before a special court, and for the purpose of the said provisions, the special court shall be deemed to be a court of session, and the person conducting a prosecution before a special court shall be deemed to be a public prosecutor. Notwithstanding anything contained in the Code of Criminal Procedure, in case of a complaint under subsection 2, the presence of the person authorized by the central government or the board before the court trying the offence shall not be necessary unless the court requires his personal attendance at the trial. Then 237. 237 talks of appeals and revision. The High Court may exercise, as far as may be applicable, all the powers conferred by Chapter 29 and 30 of the Code of Criminal Procedure on a High Court as if a special court within the local limits of the jurisdiction of the High Court were a court of session, trying cases within the local limits of the jurisdiction of the High Court. So, basically, appeals and revisions will lie to High Courts because this is treated as court of sessions. Then provisions of this code to override other laws. The provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Then to 238A, the provisions of Limitation Act apply. 239. Power to make rules. The central government may by notification make rules for carrying out the provisions of the code. And without prejudice to the generality of the provisions, the central government may make rules for any of the following. Number one, any other instrument which shall be a financial product under clause 15 of section 3. Because in section 3, clause 15, various financial products are defined. So it may make rules, namely any other instrument which shall be a financial product. Then other accounting standards which shall be a financial debt under clause D. The form, the manner and the fees for making application before the adjudicating authority for initiating CIRP by the financial creditor. The form and manner in which demand notice may be made and the manner of delivery thereof to the corporate debtor under subsection 1 of section 8. The form, the manner and the fees for making application for initiating CIRP by operational creditor. So in all these cases, the central government has the power to make rules. So these are the various powers of the central government. Then power to make regulations. So the power to make regulations is with the board. The board may by notification make regulations consistent with this code and the rules made thereunder to carry out the provisions of this code. In particular, and without prejudice to the generality of the foregoing power, such a regulations may provide for all or any of the following matters. The form and the manner of accepting electronic submission of financial information. The person to whom access to information stored with the information utility may be provided. The other information under clause subclause F of clause 13 of section 3. The other costs under clause E. The cost incurred by the liquidator during the period of liquidation, which shall be liquidation cost. The other cost. So all these things in this regard, the board may make regulations. The circumstances in which supply of critical goods or services may be terminated, suspended, or interrupted during the period of moratorium. The manner of making public announcement, last date for submission. So all these are the in regarding this, regulations may be made. Hmm. Now 240A, 240 capital A. Application of this code to micro, small and medium enterprises. So it says, notwithstanding anything to the contrary contained in this code, the provisions of clauses C and H of section 29A. Section 29A, as we all know, relates to ineligibility of resolution applicant. So the provisions of clause C refers to NPA accounts and H refers to invocation of bank guarantee. So provisions of clauses C and H of section 29A shall not apply to the resolution applicant in respect of CIRP or PPIRP of any micro, small and medium enterprises. So if there is a CIRP or PPIRP of any MSME, then clause C and H shall be ignored for the purpose of uh, assessing the eligibility of resolution applicant. Subject to subsection 1, the central government may in the public interest by notification direct that any of the provisions of this code shall not apply to micro, small and medium enterprises or apply to micro, small and medium enterprises with such modifications as may be specified in the notification. Any draft of every notification proposed to be issued under subsection 2 shall be laid before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions. If both houses agree in disapproving the issue of notification, or both houses agree in making any modification in the notification shall not be issued or shall be issued only in such modified form as may be agreed upon by both the houses as the case may be. And the period of 30 days shall not include any period during which the house referred to in subsection 4 is prorogued or adjourned for more than 4 consecutive days. Every notification issued under this section shall be laid as soon as may be after it is issued before each House of Parliament. And for this purpose, the expression micro, small and medium enterprises means any class or classes of enterprises classified as such under subsection 1 of section 7 of the MSME Act. Then section 241, rules and regulations to be laid before Parliament. Every rule and every regulation made under this code shall be laid as soon as may be after it is made before each House of Parliament, while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions. And if before the expiry of the session, immediately following the session or the successive sessions, both houses agree in making any modification in the rule or regulations, or both houses agree that the rule or regulation should not be made, the rule or regulation shall thereafter have effect only in such modified form or be of no effect, as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule or regulation. So, when we read this section 241, we know that rule or regulation may be made. It is not that they have to be laid before each House of Parliament before making them. It says made under this code shall be laid as soon as may be after it is made. So first of all, the rule or regulation is made and then it is put forth before the each House of Parliament for a total period of 30 days. Then section 242, power to remove difficulties. If any difficulty arises in giving effect to the provisions of this code, the central government may by order published in the official gazette make such provisions not inconsistent with the provisions of this code as may appear to be necessary for removing the difficulties, provided that no order shall be made under this section after the expiry of 5 years from the commencement of this code. Because it's a new law, so they have inserted this section that if any difficulty arises in giving effect, the central government may by order published in the official gazette make such provisions not inconsistent with the provisions of this code as may appear to be necessary for removing the difficulty, provided that no order shall be made under this section after the expiry of 5 years from the commencement of this code. And every order made under this section shall be laid as soon as may be after it is made before each House of Parliament. Then 243. 243 talks of repeal. Section 243. This is 243 actually, not 242. Hmm. 243 talks of repeal of certain enactments and savings. The Presidency Towns Insolvency Act and the Provincial Insolvency Act are hereby repealed. Notwithstanding the repeal, all proceedings pending shall continue to be governed by the under the aforementioned acts. Then 244. 244 talks of transitional provisions. Until the board is constituted, or a financial sector regulator is designated under Section 195, as the case may be, the powers and functions of the board or such designated financial sector regulator, including its power to make regulations, shall be exercised by the central government. And without prejudice to the generality of the powers under subsection 1, the central government may, by regulations, provide for the following matters: recognition of persons, categories of professionals and persons having such qualification experience in the field of finance law management. So when this law came, there was no exam. Without exam, professionals who had 15 years of membership, they were made insolvency professionals and they were allowed to pass the exam within a period of 6 months when this law came in 2016. Recognition of persons with technological, statistical, and data protection capability as it deems necessary as information utilities under this code, and conduct of the corporate insolvency resolution process, liquidation process, fresh start, and bankruptcy code. Then 245 to 255, they contain various amendments. 245 Indian Partnership Act shall be amended. 246 Central Excise Act. 247 Income Tax Act, then 248 Customs, 249 RDDB, 250 Finance Act, 251 SURFACI, 252 SICA, 253 Payment and Settlement Act, then LLP Act 254 and 255 Companies Act. So these are the various acts which were amended. Then there is amendment to various acts, like amendment to Central Excise Act and all those things. So this completes our part 5. Now let me see if there is anything important which we need to study. Let us have a look at various circulars which are issued. I think circulars also must be here. Let me check whether there are circulars. Circulars and clarification. Let us have a look at these circulars also.
Plus, no, not our syllabus, sir.
Huh?
Not in our syllabus, actually.
Which?
Circulars.
Why?
They removed, sir.
No, no, no.
Yes.
Circulars are very much part of the syllabus.
No, sir, no.
Why?
They taken removed, sir.
No, no, no. Actually, they have not specifically mentioned it, but naturally, whatever are the circulars, they are part of the syllabus only, unless you read the circulars, because whatever is contained in IBC, that is in our syllabus. You cannot say that circulars are not part of the syllabus.
The last syllabus it is mentioned actually. This syllabus is not they were not mentioned.
Oh, even if they don't mention, it doesn't mean that they are not to be covered. Anyway, it is not like that. Anyway, so let us attempt some case studies then.
No, sir, we will go through the circulars once.
Hmm. Fast track process. So in case of fast track process, let us see a case study on this fast track process. As you know, in case of fast track, the time limit is reduced. Fast track is applicable in case of corporate persons only, and an application for fast track may be made in respect of the following corporate debtors, namely small sized companies, which are defined under Companies Act, or startup company other than partnership firm, or an unlisted company with total assets not exceeding 1 crore rupees as reported in the books of the preceding financial year. So here assets means what? WDV, market value, gross value, none of the above. Assets here mean WDV of the assets. And what is the limit for this small company? What is the paid up capital requirement? Paid up capital requirement now is 4 crore rupees and turnover is 40
40%.
crores. And turnover here means what? Turnover means gross amount of revenue, operating revenue, sales, any of the above. What is the meaning of turnover? Actually, all these definitions, they are given in Companies Act. So you have to refer to the Companies Act. And if you refer to section 2, subsection 91 of the Companies Act, then turnover means the gross amount of revenue. I'll show you that Companies Act also side by side. Section 2, subsection 91. Hmm. I hope my screen is visible. Section 2, subsection 91. Turnover means the gross amount of revenue recognized in the profit loss count from the sale, supply, or distribution of goods. So basically, it refers to the gross amount of revenue recognized in the profit and loss count. Fast track process. So turnover means the gross amount of revenue. So as per section 55, an application for fast track corporate insolvency resolution process may be made in respect of the following corporate debtors. A corporate debtor with assets and income below a dash level. A corporate debtor with such class of creditors or such amount as dash Such other categories as may be dash. Prescribed, notified, specified, any of the above. So the answer here will be notified. As per section 55, an application for fast-track corporate insolvency resolution process may be made in respect of the following corporate debtors. Corporate debtor with assets and income below a notified level. A corporate debtor with such class of creditors or such amount as may be notified. Such other categories as may be notified. So whether any class of creditors or amount has been notified? The answer is no. Only corporate debtor with assets and income have been notified. In this case, application was admitted by the adjudicating authority on 1st of October. So when the 90 days period shall end, because in case of fast track, the period is 90 days. So when this 90 days will end? In October, there are 31 days. अक्टूबर में कितने दिन होते हैं? 31 होते हैं मेरे ख्याल। नवंबर 30 एंड दिसंबर दिसंबर में
30.
आपका इतने में हो गए, ये कितने हो गए? 61 हो गए ना ये। तो इट इज एक्चुअली टी प्लस 90।
30-12.
हाँ, तो आंसर विल बी 30-12 बिकॉज यू हैव टू सी टी प्लस 90। टी इज दिस 110। Definition of small company. Whether this company will qualify under fast track, let us see. So paid up capital is 4 crore, fixed assets 3 crores, other current assets 90 lakhs, calls in area 2,50,000, accumulated losses 7,50,000. Now what is the paid up capital here? Whether this company will qualify. So definition of small company we see, it means a company other than a public company whose paid up share capital does not exceed 4 crore rupees. So in our case, it doesn't exceed 4 crore rupees. 4 crore less calls in arrears. So this will qualify as a small company. As per section 57, which of the following is not entitled to make an application for fast track? As per section 57. Because if we read section 57, let us go to section 57. What 57 says? In case of CIRP, the corporate applicant can make the application. But as per section 57, if we go to section 57, then let us see what it says. It says that an application for fast track may be filed by a creditor or a corporate debtor, as the case may be. So only the creditor or corporate debtor. So director, KMP, promoter, nobody can make this application. So these are not entitled to make the. Otherwise, in case of normal CIRP, corporate applicant, which includes director, KMP, they can make the application. An insolvency professional was an independent director of XYZ Private Limited 2 years ago. So there is an insolvency professional who was an independent director of XYZ Private Limited 2 years ago. Can he become a resolution professional of XYZ Private Limited?
Yes. Yes. Yes.
Because it doesn't include past directors.
But suppose this is a merely director, not independent director. The scenario will be same.
I did not get your question. What is your
Sir,
question?
in this question, it is mentioned that insolvency professional was an independent director. Suppose he is merely a director, not independent. Means
Even past director is qualified. Past director is okay. Past director can become insolvency professional. So there is no bar on past directors basically.
The old items only restriction.
As per regulation 4, without prejudice to section 17(2)(d), the IRP may access the books of accounts, records, and other relevant documents and information to the extent relevant for discharging his duties under the code of the corporate debtor held with certain class of persons. So whether our IRP can ask documents lying with the advocate of the company undergoing fast track IRP? The
No.
answer will be no, because any communication between the advocate and his client is a privileged communication, and we cannot ask the advocate to part with the documents. Other professionals are covered, but not advocate. As per Regulation 6, the public announcement has to be published in one English and one regional language newspaper. You have been appointed IRP of a company having registered office in Telangana. So how will you identify the regional language? Because you may not be aware what is the regional language in every state. So what you will do, you will go to the official website of Government of India where all these things are given. Besides other information, public announcement shall provide the last date for submission of dash, which shall be 10 days from the dash. So what is the answer? The answer is given in Regulation 62C, and it says, let us read Regulation 62C of this fast track regulations. I think it is given here also, 62C. This is 62C. Provide the last date for submission of proofs of claim, which shall be 10 days from the date of appointment of the IRP. So this is the answer. Provide the last date for submission of proofs of claim. And now let us see the question. So the answer here is none of the above. Let me reproduce what is given in 662C because we may not remember. ये है 662C.
It seems B, sir. Answer seems B.
नहीं, यहाँ देख लेते हैं, इसको दोबारा यहीं कॉपी कर देते हैं, पता चल जाएगा अभी. यही था ना ये, यहाँ कॉपी मार देता हूँ इसको. अब आप देखो क्या आ रहा है. प्रोवाइड दी लास्ट डेट फॉर सबमिशन ऑफ proofs of claim, which shall be 10 days from the date of appointment. तो कोई भी आंसर नन ऑफ द अबव हुआ, क्योंकि एक में प्रूफ्स ऑफ क्लेम दे दिया, एक में डेट ऑफ अपॉइंटमेंट दे दिया. ये है ना, ये है आपका जो एग्जैक्ट वर्डिंग है यहाँ पर जो नीचे दिया है. तो आंसर इज नन ऑफ द अबव. इस तरह से कुछ क्वेश्चन बना सकते हैं हम लोग. तो आपको करना क्या है, यू हैव टू रिमेंबर ईच एंड एवरी वर्ड. भाई क्या लिखा है एग्जैक्टली. Once an IRP has constituted a committee of creditors, he shall inform the following persons regarding the constitution of COC. किस किस को बताएगा ये? कमेटी बना ली है, IRP ने कमेटी कॉन्स्टिट्यूट कर ली, किस किस को बताएगा ये? बोर्ड, एडजुडिकेटिंग अथॉरिटी, रजिस्ट्रार, ऑल ऑफ द अबव. इसका रेगुलेशन 17(1) है. एक बार रेगुलेशन 17(1) देख लेते हैं क्या बोलता है क्विकली. ये रेगुलेशन 17(1) आ गया. ठीक है. The IRP shall file a report certifying the constitution of the committee to the adjudicating authority. किसको बता रहा है? Adjudicating authority. तो आंसर इसका हो जाएगा बी. As per regulation 37(3), explanation 2, which of the following shall not be covered under connected persons? Connected persons में कौन कौन से कवर्ड नहीं है? ठीक है, ये हम देख लेते हैं. आपका रेगुलेशन 37(3), एक्सप्लेनेशन 2. ये रेगुलेशन है आपके। ये 37 आ गया आपको, आ गया। और इसमें कनेक्टेड पर्सन कौन कौन से हैं, ये 3 में आ गया। ये explanation. The expression connected person means persons who are promoters or in the management or control. So it means existing promoters. ठीक है। सेकेंड इज persons who will be promoters. तो कौन से, प्रेजेंट और फ्यूचर है, पास्ट वाले नहीं है इसके अंदर, है ना। होल्डिंग कंपनी, सब्सिडरी कंपनी, एसोसिएट कंपनी एंड रिलेटेड पार्टी ऑफ द पर्संस रेफर टू इन आइटम्स ए एंड बी। तो एक तो एग्जिस्टिंग प्रोमोटर्स है और एक जो प्रोस्पेक्टिव प्रोमोटर्स है, वो कवर्ड है कनेक्टेड पर्सन। तो अब हम अपना क्वेश्चन देखते हैं। नाउ लेट अस सी द क्वेश्चन। तो कौन कौन से कवर नहीं होंगे, जो प्रोमोटर है तो कवर हो जाएगा, ये विल बी ये भी कवर हो जाएगा। पर्संस हु हैड बीन दी प्रोमोटर्स तो ये कवर नहीं होगा, ठीक है ना। जो पास्ट वाले हैं वो कनेक्टेड में नहीं। As per Regulation 25(4), the resolution professional shall circulate the minutes of the meeting by electronic means to all members of the committee within 48 hours of the conclusion of the meeting and seek a vote on the matters listed for voting in the meeting from the members of the committee who did not participate in the meeting or did not vote at the meeting, if any, by electronic means, where the voting shall be kept open for dash from the circulation of minutes. तो क्या होगा, एटलीस्ट 24 आवर्स होगा, मैक्सिमम फॉर 24 आवर्स होगा, 24 आवर्स, एनी ऑफ दी हो, क्या होगा। तो वर्डिंग जो यूज है वो है 24 आवर्स। यहाँ पर मैक्सिमम या एटलीस्ट नहीं है। एक बार रेगुलेशन 25(4) देख लेते हैं। ये है रेगुलेशन हमारा 24। ये सी के वोट केप्ट ओपन फॉर, ये है यहाँ पर, वोटिंग शेल बी केप्ट ओपन फॉर 24 आवर्स। ये तो यहाँ एटलीस्ट या मैक्सिमम ऐसा कुछ नहीं है। तो आंसर इसका हो जाएगा 24 आवर्स, सी आंसर हो जाएगा। एज पर रेगुलेशन 22, कोरम एट द मीटिंग। A meeting of the committee shall be quorate if members of the committee representing at least 33% of the voting rights are present. ठीक है, either in person or by video conferencing or other audio and visual means, provided that the committee may modify the percentage. Modify का मतलब क्या है, इंक्रीज भी कर सकते हैं, डिक्रीज भी कर सकते हैं, या सिर्फ इंक्रीज कर सकते हैं, डिक्रीज कर सकते हैं, क्या है। तो इट में इंक्रीज और डिक्रीज दोनों, मॉडिफाई में दोनों ही आ जाते हैं। As per Regulation 37, the resolution plan shall include certain details in respect of the resolution applicant and other connected persons. Which of the following details is not covered in such details? ठीक है। रेगुलेशन 37 क्या बोलता है, रेगुलेशन 37 बोलता है कि रेजोल्यूशन प्लान shall include certain details in respect of the resolution applicant and other connected persons। ठीक है, तो एक बार रेगुलेशन 37 देख लेते हैं, फिर इस क्वेश्चन को देखेंगे। ये है रेगुलेशन 37। मैंडेटरी कंटेंट्स, स्पेसिफिक सोर्सेस, लिक्विडेशन वैल्यू, स्टेटमेंट इंटरेस्ट ऑफ टर्म्स ऑफ प्लान, मैनेजमेंट एंड कंट्रोल, एडिक्वेट मींस, डिटेल्स। डिटेल्स में क्या है, in respect of the following resolution: identity, conviction for any offense, if any, during the preceding 5 years, criminal proceedings, disqualification, if any, आइडेंटिफिकेशन, डिबारमेंट, ट्रांजेक्शन्स, ये सारा आपका आपको रेजोल्यूशन एप्लीकेंट के बारे में देना है। नाउ लेट अस सी आवर क्वेश्चन। हमारा क्वेश्चन क्या था? क्वेश्चन हमारा ये है कि कौन कौन सी चीज इसके अंदर इंक्लूडेड नहीं है। तो सिविल प्रोसीडिंग्स पेंडिंग जो है इसके अंदर, अगर आपको क्रिमिनल प्रोसीडिंग्स ही देनी है, सिविल प्रोसीडिंग्स इसमें नहीं। तो आज की कथा यहीं समाप्त करते हैं। अब ऐसा है, तो वी आर नाउ मीटिंग ऑन सैटरडे। सैटरडे को हम लोग क्या करेंगे, ये जो आपके है ना केस लॉस डिस्कस करेंगे सैटरडे को। सैटरडे को वी आर मीटिंग एट 8 o'clock एंड वी विल बी डिस्कसिंग दी केस लॉस। तब तक आप ग्रुप में लिख सकते हैं, अगर कोई भी आपको इन्फॉर्मेशन चाहिए या कोई केस स्टडी चाहिए कुछ भी, तो आप ग्रुप में लिख सकते हैं उसको। सो नाउ वी आर मीटिंग ऑन सैटरडे ऑन केस लॉस। ओके जी, गुड नाइट।
Good day.
Right, sir.
Yesterday PPT also.
हाँ जी,
Yesterday you told some PPT is there, no? Soon.
हाँ दिस पीपीटी
Yeah. Yeah.
I'll share.
Self questions.
It has already been shared, but I'll share it again. These are all case study material, so I'll share it again, no issues.
Okay.